Alright then, on to the next video today. Today we will read the Articles of Confederation and Perpetual Union, often just called the Articles of Confederation. For those who don't know, this is often claimed to be the U.S.'s first constitution. Now, I don't hold that belief, as I don't believe it was truly a country then, because this functioned more like a confederation without any real central authority. So it'd be closer in my mind to the EU, but that's just my opinion. So, let's read it and see what we would have had we not established the Constitution instead. To all to whom these presents shall come, we, the undersigned delegates of the states affixed to our names, send greeting. Whereas the delegates of the United States of America in Congress assembled did on the 15th day of November in the year of our Lord 1777, November of that year, and the 15th. And in the second year of the independence of America, we agree to certain articles of Confederation and Perpetual Union between the states of New Hampshire, Massachusetts Bay, Rhode Island and Providence Plantations, Connecticut, New York, New Jersey, Pennsylvania, Delaware, Maryland, Virginia, North Carolina, South Carolina, and Georgia, in the words following. V. Articles of Confederation and Perpetual Union between the states of New Hampshire. Yep, reading who's involved. Article 1. The style of this Confederacy shall be the United States of America. So the name. Article 2. Each state retains its sovereignty, freedom, and independence, and every power, jurisdiction, and right, which is not by this Confederation, expressly delegate to the United States in Congress assembled. The said states hereby severally enter into a firm league of friendship with each other for their common defense, the security of their liberties, and their mutual and general welfare, binding themselves to assist each other against all force, sovereignty, or attacks made upon them, or any of them, on account of religion, sovereignty, trade, or any other pretense whatever. Article 4. The better to secure and perpetuate mutual friendship and intercourse among the people of the different states in this union, the free inhabitants of each of the states, paupers, vagabonds, and fugitives from justice excepted, shall be entitled to all privileges and immunities of free citizens in the several states, and the people of each state shall have free ingress and regress to and from any other state, and shall enjoy therein all the privileges of trade and commerce, subject to the same duties, impositions, and restrictions as the inhabitants thereof respectively, provided that such restrictions shall not extend so far as to prevent the removal of property imported into any state to any other state of which the owner is an inhabitant, provided that also that no imposition, duties, or restriction shall be laid by any state on the property of the United States, or either of them, if any person guilty of or charged with treason, felony, or other high misdemeanor in any state shall flee from justice and be found in any of the United States, shall, upon demand of the governor or executive power of the state from which he fled, be delivered up and removed to the state having jurisdiction of his offense. Full faith and credit shall be given in each of the states to the records, acts, and judicial proceedings of the courts and magistrates of their state. Now I'm going to pause real quick and address a few things in the articles. Number 1, it gives a name, and it basically says, this is not a true country. Now, some would argue against that, but by effectively saying each state retains its sovereignty and independence, and every power and right not given to the Congress, effectively says they are independent. This is like an EU with a defense clause. It has freedom of trade for the most part, with shared regulations in some aspects, but it's still functionally separate states. Furthermore, they enter a firm league of friendship. Very helpful. And emphasizes the trade and other such situations. As for the property, yes, that includes slaves. Because, 1700s, it had to include slaves. Unless you wanted, say, Georgia, South Carolina, North Carolina, Virginia, Maryland, maybe Delaware. You know, if you want those guys to rise up, and maybe some people in Pennsylvania too, yeah, you kind of had to. It's one of the big things that really made it difficult to remove slavery at this time and later on with the Constitution was at least half the states you're dealing with had slaves as a major part of their economy, and almost all of them had them somewhere. And so removing slavery was basically like pulling teeth. It was not something we could just do, especially without a standing army, which because the Confederation had issues with. We'll get to that. Article 5. For the more convenient management of the general interests of the United States, delegates shall be annually appointed in such a manner as the legislature of each state shall direct to meet in Congress on the first Monday in November in every year, with a power reserved to each state to recall its delegates, or any of them, at any time within the year, and to send others in their stead for the remainder of the year. No state shall be represented in Congress by less than 2, nor by more than 7 members, and no person shall be capable of being delegate for more than 3 years in any term of 6 years, nor shall any person, being a delegate, be capable of holding any office under the United States for which he or another for his benefit receives any salaries, fees, or an emolument of any kind. Each state shall maintain its own delegates in a meeting of the states, and while they act as members of the committee of the states, determining questions in the United States in Congress assembled, each state shall have 1 vote. Freedom of speech and debate in Congress shall not be impeached or questioned in any court or place out of Congress, and the members of Congress shall be protected in their persons from arrests and imprisonments during the time of their going to and from and attendance on Congress, except for treason, felony, or breach of the peace. So, number 1, they basically just gave immunity to all of Congress. 2, if you notice, it didn't break down the houses. That's because under the Articles, there was 1 house, and there was a 1 state, 1 vote rule. So, if you're in New York and you had, say, 7 delegates, you get the same amount of votes as New Hampshire, which may have 2. You can imagine why some of the smaller states weren't too happy with this. Well, actually, they were more than fine with that part. It was the big states who really didn't care for it, because New York and Virginia were basically saying, we have more people, yet we get the same level of voice as Connecticut or Rhode Island? That makes no sense. So you can sort of see, as we're reading, why the Articles were, I'll just say it bluntly, an unabashed failure. Article 6. No state, without the consent of the United States, in Congress assembled, shall send any embassy to, or receive any embassy from, or into any conference, agreement, alliance, or treaty with any king, prince, or state, nor shall any person holding any office of profit or trust under the United States, or any of them, except any present annulment, office, or title of any kind whatever, from any king, prince, or foreign state. Nor shall the United States, in Congress assembled, or any of them, grant any title of nobility. No 2 or more states shall enter into any treaty, confederation, or alliance, whatever between them, without the consent of the United States, in Congress assembled, specifying accurately the purposes for which the same is to be entered into, and how long it shall continue. No state shall lay any imposts or duties which may interfere with any stipulations in treaties entered into by the United States in Congress assembled with any king, prince, or state, in pursuance of any treaties already proposed by Congress to the courts of France and Spain. No vessels of war shall be kept up in time of peace by any state, except such number only as shall be necessary by the United States in Congress assembled for the defense of such state or its trade, nor shall any body of forces be kept up by any state in time of peace, except such number only as, in judgment of the United States, Congress assembled, shall be deemed requisite to garrison the forts necessary for the defense of such state. But every state shall always keep up a well-regulated and disciplined militia, sufficiently armed and accounted, and shall provide and constantly have ready for use in public stores a due number of field pieces and tents, and a proper quantity of arms, ammunition, and camp equipage. Basically stuff for the camp and war. So like cooking pots. No state shall engage in any war without the consent of the United States in Congress assembled, till that of Connecticut, unless such state be actually invaded by enemies, or shall have received certain advice of a resolution being formed by some nation of Indians to invade such state, and the danger is so imminent as not to admit of a delay till the United States in Congress assembled can be consulted, nor shall any state grant commissions to any ships or vessels of war, or letters of marque or reprisal, except it be after a declaration of war by the United States in Congress assembled, and then only against the kingdom or state and the subjects thereof against which war has been so declared, and under such regulations as shall be established by the United States in Congress assembled, unless such a state be infested by pirates, in which case vessels of war may be fitted out for that occasion, and kept so long as the danger shall continue, or until the United States in Congress assembled shall determine otherwise. So this is largely about the military. Just summary. The states are the ones with the army here. This is not a standing army like we have in the U.S. in the modern era. The states had the army for the most part, and Congress would call upon them. Now, the Continental Army did exist officially, but as one who reads up will learn, they were basically unpaid. It was a whole mess. But also, it's interesting if you read it, they essentially say, yeah, you're not going to be able to negotiate with others or deal with war or any of that unless it's already agreed to, like say when some of the U.S. states were negotiating with France and Spain, or it's dealing with the Indians, because of course, Indians are an exception. Because burn them apparently. Though, as I joke about that was legitimately the U.S. policy for a lot of years. When land forces are raised, in Article 7, when land forces are raised by any state for the common defense, all officers of or under the rank of colonel shall be appointed by the legislature of each state, especially by whom such forces shall be raised, or in such manner as such state shall direct, and all vacancies shall be filled up by the state which first made appointment. Alright, Article 8. All charges of war and all other expenses that shall be incurred for the common defense or general welfare, and allowed by the United States in Congress assembled, shall be defrayed out of a common treasury, which shall be supplied by the several states, in proportion to the value of all land within each state, granted to or surveyed for any person, as such land and the buildings and improvements thereon shall be estimated according to such mode as the United States in Congress assembled shall from time to time direct and appoint. Taxes for paying that proportion shall be laid and levied by the authority and direction of the legislatures of the several states within the time agreed upon by the United States in Congress assembled. So, essentially, the states were the ones dealing with the budget, which I shouldn't need to explain is a disaster for a number of reasons. Imagine having to go to your neighbor and say, hey, would you kindly pay for this war that's currently affecting me and me alone? Yeah, that's not going to end well. As a matter of fact, that's a lot of the things that the states complained about was when it was another state's problem, they would say, no, we don't want to pay. At the same time, they would gladly ask the other states to pay when it was their problem. Needless to say, it didn't work. Also, I'm currently looking at a dog. He's over there. So I can't show it to him. He's kind of relaxing, and I've got this set up so I can't really move my recording. Alright, Article 9. The United States, in Congress assembled, shall have the sole and exclusive right and power of determining on peace and war, except in the cases mentioned in the 6th article of sending and receiving ambassadors, entering into treaties and alliances, provided that no treaty of commerce shall be made, whereby the legislative power of the respective states shall be restrained from imposing such imposts and duties on foreigners as their own people are subjected to, or from prohibiting the exportation or importation of any species of goods or commodities whatsoever, or establishing rules for deciding, in all cases, what captures on land or water shall be legal, and in what manner prizes taken by land or naval forces in the service of the United States shall be divided or appropriate, of granting letters of marque and reprisal in times of peace, appointing courts for the trial of piracies and felonies committed on the high seas, establishing courts for receiving and returning, finally, appeals in all cases of captures, provide that no members of Congress shall be appointed a judge in any of said courts. The United States in Congress assembled shall also be the last resort on appeal in all disputes and differences now subsisting, or that hereafter or any other cause whatever, which authority shall be exercised in the lawful, in the manner following. I'm lost. Or that hereafter may arise between two or more states concerning boundary, jurisdiction, or any other case whatsoever, which authority shall always be exercised in the manner following, whenever the legislative or executive authority or lawful agent of any state in controversy with another shall present a petition to Congress stating the matter in question and praying for a hearing. Notice thereof shall be given, by order of Congress, to the legislative or executive authority of the other state in controversy, the day assigned for the appearance of the parties by their lawful agents, who shall then be directed to appoint, by joint consent, commissioners or judges to constitute a court for hearing and determining the matter in question. But if they cannot agree, Congress shall name 3 persons out of each of the United States, and from the list of such persons, each party shall alternately strike out 1, from petitions beginning until the number shall be reduced to 13, and from that number, not less than 7, nor more than 9 names, as Congress shall direct, shall, in the presence of Congress, be drawn out by lot. The persons whose names shall be so drawn, or any 5 of them, shall be commissioners or judges to hear and finally determine controversy. So always as a major part of the judges who shall hear the cause shall agree in the determination, and if either party shall neglect to attend at the day appointed, without showing reasons which Congress shall judge sufficient, or being present shall refuse to strike, the Congress shall proceed to nominate 3 persons out of each state, and the Secretary of Congress shall strike in behalf of such party absent or refusing, and the judgment and sentence of the court to be appointed in the fusing, the judgment and sentence of the court to be appointed in the fusing, and the judgment and sentence of the court to be appointed in the manner before prescribed shall be final and conclusive. And if any of the parties shall refuse to submit to the authority of such court, or to appear or defend their claim or cause, the court shall nevertheless proceed to pronounce sentence or judgment, which shall in like manner be final and decisive. The judgment or sentence and other proceedings being in either the security of the parties concerned, case transmitted to Congress, lodged among the ex-Congress for the security of the parties concerned, provide that every commissioner, before he sits in judgment, shall take an oath to be administered by one of the judges of the Supreme or Superior Court of the state where the case shall be tried, well and truly to hear and determine the matter in question, according to the best of his judgment, without favor, affection, or hope of reward, provided that no state shall be deprived of territory for the benefit of the United States. Now, this was a whole bunch of stuff about the law and specifically resolving disagreements. You might notice, though, there is no Supreme Court. Basically, everything was done by Congress. So, as a result, this was a one-house legislature, with the executive being the head of said legislature, similar to a prime minister, but slightly different. And, along with that, there was no Supreme Court. They would judge with Congress appointing judges. So, yeah. Well, actually, the states appoint the judges, but even still, you can definitely see that the checks and balances we had in the Constitution, we're not seeing them here. Instead, the checks and balances are basically, let us devolve everything to the states, which does not last that long. Furthermore, I'll continue with the article because it apparently keeps going. All controversies concerning the private right of soil claimed under different grants of 2 or more states, read Pennsylvania and Connecticut, because those are the big ones, whose jurisdiction as they may respect such lands, and the states which pass such grants are adjusted, the said grants, or either of them being at the same time claimed to have originated antecedent to such settlement of jurisdiction, shall, on the petition of either party to the Congress of the United States, be finally determined as near as may be, in the same manner as is for prescribed for deciding disputes respecting territorial jurisdiction between different states. The United States, in Congress assembled, shall also have the sole and exclusive right and power of regulating the alloy and value of coins struck by their own authority, or by that of their respective states, fixing the standard of weights and measures throughout the United States, regulating the trade and managing of all affairs with the Indians, not members of any of the states, provided that the legislative right of any state, within its own limits, be not infringed or violated, establishing and regulating post offices from one state to another, throughout all the United States, and exacting such postage on the papers passing through the same, as may be requisite to defray the expenses of the said office, appointing all officers of the land forces in the service of the United States, excepting regimental officers, appointing all the officers of the naval forces, commissioning all officers whatever in the service of the United States, making rules for all officers whatever in the service of the United States, making rules for the government and regulation of the said land and naval forces, and directing their operations. The United States, in Congress assembled, shall have the authority to appoint a committee to sit in the recess of Congress. Jeez, this one just keeps going. Anyways, we shall continue. To sit in the recess of Congress, to be nominated a committee of the states, and to consist of one delegate from each state, and to appoint each other committees and civil officers as may be necessary for managing the general affairs of the United States under their direction, to appoint one of their number to preside, provided that no person be allowed to serve in the office of president more than 1 year in any term of 3 years, to ascertain the necessary sums of money to be raised for the service of the United States, and to appropriate and apply the same for defraying the public expenses, to borrow money or emit bills on the credit of the United States, transmitting every half year to the respective states an account of the sums of money so borrowed or emitted, to build and equip a navy, to agreed upon the number of land forces, to make requisitions from each state for its quota in proportion to the number of white inhabitants in such state, which requisitions shall be binding, and thereupon the legislature of each state shall appoint the regimental officers, raise the men, clothe, arm, and equip them in a soldier-like manner at the expense of the United States. And the officers and men so clothed, armed, and equipped shall march to the place appointed, and within the time agreed on by the United States in Congress assembled. But if the United States in Congress assembled shall, on consideration of circumstances, judge proper that any state should not raise men, or should raise a smaller number than its quota, and that any other state should raise a greater number of men than the quota thereof, such extra number shall be raised, officered, clothed, and equipped, armed as well, in the same manner as the quota of such state. Thus the legislature of such state shall judge that such extra number cannot be safely spared out at the time. Yeah, that's going to lead to several loopholes. In which case they shall raise, officer, clothe, arm, and equip as many of such extra numbers as they judge can be safely spared, and the officers and men so clothed, armed, and equipped shall march to the place appointed, and then the time agreed upon by the United States in the Congress assembled. The United States in Congress assembled shall never engage in a war, nor grant letters of marque or reprisal in time of peace, nor enter into any treaties or alliances, nor coin any money, nor regulate the value thereof, nor ascertain the sums and expenses necessary for the defense of and welfare of the United States or any of them, nor emit bills, nor borrow money on the credit of the United States, nor appropriate money, nor agree upon the number of vessels of war to be built or purchased, or the number of land or sea forces to be raised, nor appoint a commander-in-chief of the army or navy, unless 9 states assent to the same, nor shall a question on any other point except for adjourning from day to day tone unless by the votes of the majority of the United States in Congress assembled. The Congress of the United States shall have power to adjourn any time within the year and to any place within the United States, so that no period of adjournment be for a longer duration than the space of 6 months, and shall post the journal of their proceedings monthly, except such parts thereof relating to treaties, alliances, or military operations, as in the judgment require secrecy, and the yeas and nays of the delegates of each state on any question shall be entered on the journal, when it is desired by any delegate, and the delegates of a state, or any of them, at his or her or their request, shall be furnished with a transcript of the said journal, except such parts as are above accepted, to lay before the legislatures of the several states. Long one, but it's basically establishing rights of coinage, how the military functions, and all other such things. So, it's basically a giant bundle. Frankly, it could do as 3 articles, but regardless, the rule is you can't borrow money without 9 assenting, which is a supermajority. Actually, I think it's more than that, because that'd be 2/3. Yeah, I think it would be. So, it's close to 3/4, but still. So, there's that, obviously. Then there's the fact that the armed forces shall be appointed by the United States government. And the fact that a state can just declare, yeah, we cannot safely spare this amount of people at this time. I hate to break it to the people writing this at the time. I get they were trying to weaken the federal government so that they actually had, states' rights. But at the same time, that is the biggest loophole I have ever heard of. You cannot run a country on patriotism alone. Article 10. The committee of the states, or any 9 of them, shall be authorized to execute, in the recess of Congress, such of the powers of Congress as the United States, in Congress assembled, by the consent of 9 states, shall from time to time think expedient to vest them provided that no power be delegated to said committee, for the exercise of which, by the laws of Confederation, the voice of 9 states, in Congress of the United States assembled, is requisite. So, how much is required to get a quorum present and actually start voting on things? 9. You need 9 people. Also, whole thing's organized weird. Article 11. Canada, acceding to this Confederation and joining in the measures of the United States, shall be admitted into and entitled to all the advantages of this Union. But no other colony shall be admitted into the same unless such admission be agreed to by 9 states. See, this is the interesting thing about Canada, or the Canadian colonies rather, because they were split up among Quebec, Upper Canada, the Hudson's Bay Company, and several others. Canada, just the general colonies, was considered American for basically its entire early history, during the Revolution and later on. It was only recently that it really started to diverge. Well, I say recently. Around the 1860s, when Canada actually started confederating and uniting into, the current dominion we see now. Interesting fact, actually. The Canadians were tired of their government once and revolted, almost joining the United States in the 1830s. So having this article here is interesting, even if it's rather worthless. Because let's face it, it didn't matter what Canada thought. If they had British troops in it, their thought was, I don't want to get shot. Article 12. All bills of credit omitted, monies borrowed, and debts contracted by or under the authority of Congress before the assembling of the United States, in pursuance of the present Confederation, shall be deemed and considered as a charge against the United States, for payment and satisfaction whereof the said United States, the public faith, are hereby solemnly pledged. Essentially, we're going to pay off our debts. Totally. Yeah. We've been in debt since Andrew Jackson, so unlikely. But hey, maybe the articles would have been different. Yeah, nah, probably not. Article 13. Every state shall abide by the determinations of the United States in Congress assembled on all questions which by this Confederation are submitted to them. The articles of this Confederation shall be inviolably observed by every state, and the Union shall be perpetual, nor shall any altercation at any time hereafter be made in any of them, unless such alteration be agreed to in a Congress of the United States, and be afterwards confirmed by the legislatures of every state. And whereas it hath pleased the great governor of the world to incite the hearts of the legislatures, respectively represented Congress, to approve of and to authorize us to ratify said articles of Confederation and Perpetual Union. Know ye that we, the undersigned delegates, by virtue of the power and authority to us given for that purpose, do, by these presents in the name and in behalf of our respective constituents, fully and entirely ratify and confirm each and every of the said articles of this Confederation and Perpetual Union, and all and singular the matters and things therein contained. And we do further solemnly plight and engage the faith of our respective constituents that they shall abide by the determination of the United States in Congress assembled on all questions which by the said Confederation are submitted to them, and that the articles thereof shall be inviolably observed by the states we respectively represent, and that the Union shall be perpetual. Yeah, sure about that. In witness whereof we have hereunto sent on our hands in Congress, done at Philadelphia in the state of Pennsylvania, the 9th day of July, in the year of our Lord 1778, the third year of the independence of America. Now, I'll say it bluntly, that is not a country's document. That's closer to like the chart of the EU, and let's face it, the EU isn't a country. The Articles of Confederation were notoriously weak, and you could sort of see why. Not only was it poorly thought out in terms of how much power they gave to the states, but also just the military alone wasn't very well cared for. Now, as a lot of people explain when they're teaching this, and they're right for it, with how much people were complaining about Britain's overreach on the colonies as they started enforcing their rule, the natural response was to swing the other direction hard, resulting in a very weak government. The founders were intelligent on several accounts, but this is something that all humans do for the most part. It's a common thing of progress and reaction, where things progress to a point, and then there's a reaction resulting in push to the other direction. So what happened later was essentially, after realizing, oh right, we actually have to make a country that works, after passing the Northwest Ordinance and other things, eventually, in order to form, well not form, it was originally to actually fix the Articles of Confederation, but what they did was they said, alright, to fix it we'll hold a convention to hopefully sort out all the problems with it. Instead, it was basically a coup. They closed the doors and said, alright, share freely what you wish to do. Also, we don't need to follow the rules of the Articles to get this new thing we're making pass, so we can just, do as we desire. Yeah, it was basically a coup. But that's all the time I have for today, so have a good one.